British did so not for our interest, but for their own colonial and imperialist interest. They did this because segregation of the northeast tribals from the rest of mainland India was done because they recognized that fear of being overwhelmed by more advanced people from mainland India would likely cause insecurity and unrest amongst the locals. They recognized that any social unrest among the local tribal population was therefore detrimental to their own economic interests in the region. They saw that curbing migration of outsiders into the northeast was essential in ensuring peace and good governance. That is the main crux. Thus, the first ever government regulation to protect the tribals from outside domination was the Bengal Eastern Frontier Regulation 1873, or the popularly known Act as the Inner Line Permit System. Today, the region is still unsure as to the benefits or demerits of this regulation. The regulation has served to isolate the region from the outside world. True. We have been cocooned. So in a globalized world order, have we or are we to be turned into specimens? Can the preservation of culture and tradition go side by side with the demands of a globalized economy? This is another question. The answers are not clear. We don't have answers. We're still struggling to come up with answers. Only time will tell. The second phase of this so-called isolating or giving social justice to the tribals of the Northeast started with 1947 with the advent of Indian independence. The preamble of the Constitution speaks of a solemn resolution by its citizens to constitute a sovereign, socialist, secular, democratic republic and to secure for its citizens, number one, social, political, and economic justice. Today, therefore, in a social welfare state, comprehensive growth and development of the region and of its people has become a priority. As a parliamentary democracy, India has given recognition to the historical and geographical factors behind the backwardness of this region. At one point of time, we were called backward tracts. Please remember that. The task of nation building demands the need to not only politically integrate the region with the rest of India, but also for it to become emotionally and economically one with the rest of the country. A very important aspect. At the same time, there is also this undeniable need for constitutional and legal support systems to ensure the cultural and political integrity of Northeast tribes as they attempt to integrate themselves with a rapidly changing world order. The Federal Republic of India has tried to do this. Let us examine whether it has worked or not. Today we spoke about the need to deliver social justice. One of the constitutional aspects that India has formulated to deliver social justice to the tribals of the Northeast is a most ambitious and unique legislative experiment undertaken anywhere in the world, and it's called Sixth Schedule of the Constitution. It provides the tribals of the Northeast with extra constitutional privileges to enable them to grow within their own ingenuity. Classic statement, it still rings out with the promise it holds. With this in mind, we've been given constitutional powers to determine and shape the management of our lands, forests, social customs, and protection of our economy. When we turn to the ADCs, when we turn to the creators of, to the results of the Sixth Schedule, the ADCs, we find that here is where we have really stumbled, and we have stumbled miserably. When we talk about social justice as far as the ADC's ability to come up with laws for the management of our land. I, as a cousin, I was shocked when I traveled into interior West Coastlands to find landless cousins. We have not been able to make laws to ensure that there has been equitable distribution of land amongst our own people. When we talk about the protection of our economy, precious little has been done by the district council except to enhance and to enact the trading license regime. Nothing else has been done. When we talk about poverty in this region and that social discrimination, poverty is an issue of social discrimination. I go back again to what the Vice Chancellor said. We need to define what is poverty. Is having money poverty? Do we class the BPL class as people who don't have enough income? Or is poverty something else? Can we define poverty as the inability of people to access resources? Common, identified, taken for granted resources. I take for granted that my child and me and every one of my acquaintance has a chance to go to school, has a chance to proper health care, has a chance to good food. Can I say the same about people elsewhere? And especially in our rural areas. I'm sorry, but there are people who struggle just to gain proper health care for themselves. So this is poverty, not the question of having money or not having money. And here's where I feel that the ADCs, the byproducts of the 6th schedule within Northeast India, have totally failed the mandate given to them. The 6th schedule was a good intention, no doubt. We have not been able to make it work. Today we look around and ask ourselves if the ADCs are still relevant. There has been this subconscious tickling in the back of our minds whether this mechanism to deliver social justice is working or not. And somehow the answer seems to be no. We need to ask ourselves. It's a sad reflection on how we are, the tribals have misused their constitutional provisions for the 6th schedule. The biggest drawback of the ADCs lies in their proposition. We have to analyze why the ADCs are not working. ADCs means the autonomous district councils. They are composed of political parties and political entities who simply exist because of the need to acquire new power. The spirit behind the 6th schedule, the provisions of the schedule to capacitate the indigenous people of the region has been lost sight of. They have been replaced by a need to please an electorate or a constituency. The ADCs have simply become another administrative institution existing amongst a multiplicity of similar institutions, all fighting for the same shrinking resource base. The ADCs simply add to chaos of governance. They do not serve any meaningful purpose. One therefore comes to the sad conclusion that this constitutional protection for the tribal to ensure social justice and the question of egalitarianism amongst ourselves is not working. It has therefore to be either revamped or to be consigned to the dustbin. We have to make up our minds. Then we come to the creation of these, again, as a measure of social justice for the tribals of the Northeast. We come to the creation of these. It's a not popular statement to make, but it has to be made. The creation of these economically non-viable tribal states of the Northeast. They are not economically viable. They're just there for emotional reasons. Meghalaya is one. We have to accept that. We try to make it work. But then again, it is a knee-jerk response towards the need for social justice in the Northeast. Is it? I think it's a political opportunistic approach to social justice. And then we are settled. These states have become hotbeds for sordid and parochial politics, adding nothing to the development of the region, nor to the general welfare of the nation. In such states, another aspect of social justice is the issue of reservation for locals. It is a burning issue that sustains not only the sentiment and the emotions of local travelers, but also it sustains the aspirations of debunked politicians and their political parties. However, reservation, if we look at it, the way that it's being implemented, a good intention again, it has simply instilled a sense of complacency and robbed most of us of the spirit of competition that is so essential for survival. We have to accept this. Taken from the historical perspective, social justice for the travelers is necessary. Assessing the manner in which we have politicized the issue makes us wonder if this really is such a good thing after all.
Every country has a special system to deal with children under the juvenile justice system, and the special system is basically a welfare approach. That is something that has been used by many countries, including India. The whole concept beside that, why do we do welfare system when we are actually dealing with a juvenile? The law, as India has signed the Convention on the Right of a Child, the CRC, it brings together that children should actually be given a chance to get on a better life and to be able to reform oneself. That's the why we have the juvenile justice system, which is actually taking the condition of the CRC, and as a country rectifying that CRC, we follow and come in with the juvenile justice system, or the JJ Act. As we all today we talk about the Juvenile Justice Act 2000, the Amendment 2014. It all came because of the CRC, and India complies by those norms. And when we talk about the justice system, we are talking about when a juvenile commits a crime. We are talking about, do we take the child to jail or do we take him for, reformation? Under the Juvenile Justice Act, we are talking about reformation so that the child can really have, can be able to reform, and after he becomes 18 and above, he gets on to move on with life, and he's not treated as a criminal and he's not detained in jail. But the challenge of the JJ system, I think we all have been reading the kind of crimes being committed nowadays. I think the biggest one is the Delhi rape, where one of the person who committed the crime is a juvenile. And I think after that, when we had the amendment on the law on rape, this biggest debate came in for organizations like us and many, many other organizations in the country. Do we change the age of a child or a juvenile? Because of the JJ Act, the way the law is dealing with him is providing him the facilities and the support system under the JJ, which means reformation. And that is still the biggest question, the biggest debate, because today we find that many, many more children are growing very fast. At one time, under the JJ, we are agreeable that the age of a child should be 18. Until today, we follow by the norms. But then we have another school of thoughts that says that children are growing very fast. The minds of children are more like, a 16 years old is more like a 20 years old in today's generation. So do we still have to deal with that? If he commits a crime, should he be dealt like an adult? If the crime is a punishable crime? Or do we still deal under the juvenile justice system? I think for me, who have worked with children for many years now, for the last 15 years, of course it's not agreeable that the age of a child should be changed, but of course each one of us here have our own opinions and our own ideas and why we want the child to be 18 and not 18. The whole concept of the juvenile justice system, when we talk about welfare concept, we have realized that the JJ Act has provided two divisions. One is the juvenile justice, we call the JJ board, the juvenile justice board, and one is the child welfare committee. As per the law, it's mandatory that every state has a JJB and a CWC. And in principle, in paper, in document, this is in existence. But in practice, I think, like what ma'am has said in her opening, the social justice is still a far cry. Why is it so? The whole concept about creating a JJB is to have sensitive members who are appointed as members, or who have background on dealing with children, whether they are in the CWC dealing with children in need and care or protection, or in JJB dealing with children, juvenile justice crime, delinquent crimes. But what we have seen that when it comes to the urban context, maybe we see things a bit differently, because the people who are in these boards are a little well versed, or they have a little bit more knowledge comparing to those members or chairperson who are in the district level or far off. Because at the end of the day, the way things are being dealt, when I was part of the Supreme Court review committee for all the juvenile justice system in the country, what I've seen is that the way the chairperson, who is a judicial magistrate, as well as the members, when they're dealing with juvenile crime, they have not really understood that dealing with juvenile crime means giving the chance to that child to be reformed. But because of the lack of training, the lack of understanding of child rights, the lack of way of how a social justice delivery system should be given to children, that children are repetitively committing the same crime again and again. I have been in the JJB for 4 years when they started the JJB in East Khasi Hill district. It's very interesting to see that a child has committed a crime when he was 14, but he still appeared in the JJB even when he was 22 and 23. And that's just not my experience. It's an experience of many JJB in the country, because the case has been pending for long. So you can imagine, for a chairperson or members like me, we have to deal, the modality, the rules is to deal exactly for a person below the age of 18. But if the person is already 22 and is appearing in the child, in the JJB, in terms of psychologically, the person is a matured adult. So whatever he might have spoken for, when he was 14, and when when he has to give a statement when he's 23, these things are not the same anymore. When he's 23, he's being represented by his lawyer. When he was 14, he was brought as a child who committed a crime. So what I would like to bring in here is that the most important factor is that chairperson and members of JJB, of course similarly with CWC, has to be very, very well trained. Unless they prolong the case for too long, that the person is appearing again and again and his age is passing. And what happened is, we have the case of numbers is increasing and there's no reduction of that kind of cases to go down at all. And that is not a progressive way of dealing with juvenile justice in a context of dealing it properly. The other angle of dealing with child is the kind of minimum standard to be applied in a JJ system. What I've seen and reviewed is that many of the people who are sitting there thinks they're dealing with that child like a mother, I've seen the concept of communication in a system of a JJB. You're not to be there like a mother treating a child. There has to be ways and means of dealing with those cases. And that has happened is because of the lack of training and the lack of exposure. Because some of them are just being put there, they have no clue. My team at the organization, when they're dealing with different JJB or CWC, they're constantly explaining to the member, this is the way you have to do it, this is the way you have to do it, So then you realize that the person sitting in that position is unable to deal or deliver social justice system for a juvenile. And that is something which is very, very challenging, because children get frustrated and you see that they commit the crime again and again because of the frustration of how they're being dealt when they're being brought in. That's one very, very important element. The other factor is that there have been many conventions which deals with the juvenile justice system in the country. And for some of these conventions, one is the CRC that I've mentioned, then we're talking about the UN guideline for the prevention of juvenile delinquency, the Riyadh guidelines. Here I talk about system of counseling, the process of integrating the child into the community, the process of ensuring that the child is getting all the support system so that he's not repeating the crime again. But just having a JJB is not enough because the support system or the service delivery system that they need to do referral is not available. So it doesn't become very holistic in the way these systems are being dealt. The other one is the African Charter on the Right and Welfare of the Child. This is again in terms of community aspect of dealing with these cases. So these are elements that one needs to really put together when we are talking about the social injustice. With that, what I would like to bring forward, I think as a message, or when those who are documenting this in the seminar today, is that institution, whether it's ICFAI or many other universities and colleges, can do is provide support system in terms of interaction with JJB and CWC, with students, with the institution faculties, because that will enlarge the understanding or give a better understanding of what JJ system is all about, how children has to be dealt. Because today we see more and more of crime being committed by children are in schools and colleges. With cybercrime, most of the crime, it's a juvenile justice crime. Today things are changing. What we dealt 10 years ago, it's crime where a child would go and steal something from a shop, do some other kind of crime. But today it's becoming more complex. The juvenile justice system is becoming more complex because the kind of crime committed by juveniles are so much to do with the IT or the IT world or the cyber crime that they're dealing. And these are becoming more harmful and more challenging. And the most important element is to integrate these kind of awareness, coordination and discussions so that it also brings down the level of crime which is being committed by children. Because today, most of you use MMS, and that's the biggest crime, but we don't know how to deal with such crime. Most institution has got Wi-Fi, which is important for the element of education. But then most of the Wi-Fi are being misused. So these are elements. We need telephone, we need cyber cafe, we need all of it. But we also have to look into crimes related issues which are being committed by children, because that is the most important age, because they tends to, bullying is also done on cyber, on cyber world. They bully children, they rape children, they also commit crime against girl child. So these are elements which is very important, and I think one needs to look into that, how educational system can actually integrate these kind of support systems so that we reduce the juvenile crime. Thank you.
I think I'll prefer yes. Good afternoon. I'd like to thank my teacher, who is also the moderator. And it's good that we are together on this platform. And I think all the four people are well known to each other. And occasionally I think I do meet Bathunjing too, so we're quite at home. Thank you to the university for inviting also me to be part of this deliberation. I come from the discipline of sociology, and therefore there are certain matters that the way we look at will be basically from that discipline. And in the observation of a sociologist is that if you talk about the humankind, right from probably whatever period of time when we formed the humankind to the present times, I think one of the biggest challenges will and always be between ideal and real. What is ideal and what is real? And I think that is a constant, going in the challenges. And I think society and social modes, dividing factors which enhance social injustice. Initially I was quite puzzled because a lot of things are there inside. But I thought for the purpose of the panel discussion, I would just like to highlight on certain key issues, probably that you the audience, are able to process in your mind, this whole idea and able then later on to enter into an engagement with all of us here and to clarify certain points. But also I think we need to understand we are not from the Ministry of Social Justice and Affairs that probably we can solve problems that you may ask. We will try to only to answer the question, but solving problem I think I have to call on the government that is at present today. Or the judiciary that is supposed to be there to solve certain problems. But as my colleague sitting on the end side has already said, from 18 to 23. So we're only seeing how we're solving problem. Anyway, for those who are not from the discipline of sociology, I think the first thing is to able to grasp this terminology, what we say as social mores or social norms. When we use this word, for us particularly, social anthropologists, when we say social norms or social mores, it means that these are customs, conventions, embodying the fundamental values of any given society. So all of us who are sitting here, all of us are carrying or are the embodiment of those customs, those traditions which we have inherited over generations from our ancestors. And that is I think the need for us to understand. And the question that comes is, do we think that social mores enhance social justice? Does it really create a condition for social injustice? And I think that is a question which I cannot even give you a full answer, because we have to look at whether it is or not. Secondly, the moment we use the word social justice or social injustice, these were terminologies that evolved in the later part, what we call as the modernizing of the modern man. And these words, these terms were constructed and they became part of the modern political state, and particularly used by the modern state, in social aspect. So we have that as a way of understanding, this issue of social mores and social justice or injustice. For example, where would you see social injustice if you're talking about, for example, if you're talking about these social norms and traditions? Every community I think in the world, they have with them good values. They have good values. Some good traditions are there. We cannot, I think it will be very difficult for me to generalize, to say that all traditions are bad and they promote social injustice. I think that is an incorrect way. I cannot generalize. But we may be able to say that certain social mores or certain traditions that societies follows may also carry with them some of the things that we can put it under a box called social injustice. For example, if I take in the context of, I'm using this as illustrations. If I take in the case of the Khasi society, then there is this such a fundamental principle, or what I used to say, a cardinal principle of life that says in Khasi it reads as Kamaya Kahao, but in English, if I put it in a really holistic sense, it carries these two important words, that is truth and justice. And in accordance with the social norms of the community, all of us who accept that we are part of that society are supposed to carry out our life on a daily basis, on minute to minute, in our interaction, in our decision making, in our conduct with another human being, whether they are Khasi or not. Whether they are Khasi or not is immaterial, on the basis of the cardinal principle of justice and truth. Now, the problem, the challenges, and there's what you see, that social actors, let's say of the community, may not conform at all times, at all situations, to the cardinal principle, but rather may carry out their own action. One or more of them, very many more actors get together either a group of 2, a group of 10, a group of 1,000 or 100, act together in a way which basically in us against. For example, if we are saying that if I'm I'm in charge of taking decisions to ensure that all the programs of the department is supposed to lead to poverty alleviation of those constituency within where I'm supposed to carry out. But I take a decision that the benefit is for somebody else, but not for those. Then that's where I see is the act of there I see how it's not a questioning of the social modes, but how the person acted against the social modes of the community, and therefore in the process what has happened is has promoted all kinds of injustices, and this can happen in various kinds of situations. For example, another example that I can cite to you, or when we moved away from the good values and cardinal principles, and I think that's where the challenge is, that when the humankind moves away from the cardinal principle, and I think that's where the issue of social injustice comes in, because they may act contrary or against the good values or the good norms.